Hello all. This is a criminal procedure topic, pretrial release, and that includes bail as well as non-financial methods of releasing defendants pretrial. And it's linked to Chapter 2, Part A of the Miller and Wright text, Prosecution and Adjudication. Let me offer a few observations about why this is an important topic. First of all, just in terms of simple liberty, lots of days of real human beings' freedom is at stake here, and real questions about community safety are at stake here. It's also very interesting from an institutional standpoint because we've seen huge changes in practice in this area of pretrial release over the last half century, and almost none of it has been driven by the federal Constitution. As your reading indicates, the federal Constitution doesn't require the government to impose bail. It just allows the government to impose bail when not excessive. There are many state constitutions that do require the setting of bail in all but capital cases. So this is a matter that is sometimes governed by state law, but it's an interesting area of interaction among different sources of law and different legal institutions. So in that sense, it's a fascinating topic for students of the law. The plan here will be to cover three big topics under this heading of pretrial release. The first is to give you a sense of bail outcomes or release outcomes way back when, about a half a century ago. And then second, to give you an idea of release outcomes now, how things have changed over a half a century. And then finally, we'll be talking about the who and the when of bail. Who is it who's influential in making release decisions, and when in the criminal process does that happen? That will set us up for a conversation about mechanisms for pretrial detention later on. All right, so let's think back half a century, think back to the middle of the 20th century. How many felony defendants were being detained at that point in the period between their arrest and their trial? Nationally, about 54%, so over 50% of the felony defendants were being detained. In some states, over 2/3. And who was setting those bail amounts? Mostly by the trial court, but it could also happen on the decision of clerical personnel for the court or for the police. The clerk of the court might just follow some written instructions from the judge, or the police might be using something that's called station house bail, where they would just follow a set of preset guidelines for determining the payments that one would have to make to be released. But release was the exception, not the rule, as of the middle of the 20th century.
I have a cup of coffee this morning. Please feel free to join me. In addition to the number of defendants who were detained pre-trial in that period between arrest and trial in the middle of the 20th century, just as that number has changed over time, so too the method of holding those defendants has changed. So it once used to be the case that financial mechanisms such as surety bonds were overwhelmingly the method used to release those defendants who were released, whereas now non-financial mechanisms for release have become somewhat more important. So enter the Vera Institute in New York. This is a thrilling story for a researcher like me, because this is one of those times when my people, the researchers, made a difference. And more seriously, my teacher and mentor and friend Dan Freed was an important author and designer of this study. The basic idea, as you know from the reading, is that law students went out, interviewed defendants, and initially were to make recommendations to the court about which of those defendants should be released on their own recognizance. Initially, the students involved in the study were quite reluctant to do that on a subjective basis, and so the project developed a point system. And on that basis, the court was willing to release some defendants and to keep to the other side a control group to measure what happened as between the two groups. By looking at the release group and the control group, the folks putting together this study were able to estimate the effects of pretrial detention. And they noticed two major things. First of all, conviction is more likely if you're detained pretrial than if you're not. If you hold all the other variables constant, as the creators of this study tried to do, 40% of those released were convicted, and 77% were convicted from the control group, those who remained in custody. Detention also makes a prison sentence more likely within the group of those who were convicted. So 16% of the defendants who were released received prison versus 96% of the control group. Now, how do you explain this difference? How do you explain the impact? It may be, for instance, that if you're released, it's just easier to gather evidence and to help your attorney find witnesses and to get ready for trial. It could also be that judges tend to release defendants with less serious cases or cases with less viable defenses, so that despite some external similarity between the control group and the release group, judges were still perceiving some differences between those groups. So what were the bottom line recommendations from the Vera study? First of all, the Vera study suggests that judges should really zoom in on local ties of defendants. Defendants who have jobs, families, other reasons to stay, tend to stay. Defendants who don't have local ties and you just release them and tell them to show up some weeks or months from now in court, they tend not to show up. So the Vera study suggested use of a point system to quantify for judges the strength of the local ties that would be likely to bring a defendant back into court. And as you read, they include things like +3 for having a job or currently attending school, +3 if you have lived for 1 year at your present residence, +3 if you live in the family home and you visit other family members regularly, -2 for multiple prior felony convictions. You get the idea. A point system that measures in a rough way your likelihood of staying based on the local ties. Now, the Vera Institute study predicted some changes that had just begun in the middle of the 20th century, and the Vera study itself created and speeded some of those changes in practice. And to this day, the Vera Institute exists and does very interesting pilot studies that have an impact around the country. They get replicated in many other places. Typically, they start off in New York somewhere, but then they get picked up if they seem to work and save money and so forth. Now, how have release decisions changed since the days of the Vera study? We have in front of us here some figures from the Bureau of Justice Statistics, their periodic survey of practices for felony defendants in state courts. And one number in particular I want you to notice is this one here. Nationally, between 1990 and 2004, on average, 62% of all felons were released. Again, there's going to be a good bit of variation between states, but national average 62%. Flip side, 38% were being held. Compare that to the 54% figure back in 1960. So 38% being held now as opposed to 54% back then. So more defendants are being released, fewer are being held these days. Another change is that the non-financial conditions became more prevalent after the Vera Institute study. Although, as you see here, the financial release methods have increased some during the period between 1990 and 2004, and the non-financial release reasons bounced down a little bit, but then bounced back up some. Now let me describe to you the non-financial release mechanisms that are commonly used today. And this covers just over half of the releases that happened, although that's been trending down over the period since 1990. First of all, there's ROR, Release on Own Recognizance. And that's just what it sounds like. The judge just says, go and show back up next Thursday or whatever the court date is. There are also conditional releases, where the court will say, I'll let you go, but there are certain conditions you have to meet. The Alabama Rule 7.3 that you read is fairly typical here because it has both mandatory conditions, can't leave the state unless you inform the court. If you change residence, you got to tell us about it. You can't commit another new crime. If you do, we'll pull you back in. There are also, non-mandatory conditions that the court could impose. Things like you can go out for certain hours, but you have to come back to the jail after, by 6 p.m. every day, or you have to stay with Cousin Bob, or you have to stay away from, this neighborhood, or stay away from this person. So various specialized conditions might also attach to the release. There are also certain kinds of emergency releases where the court will just order people released because of jail crowding conditions. So I've talked about the non-financial release mechanisms. Now let's walk through the financial release mechanisms where money's involved. The most common one is also the oldest one, and that is surety bond. With this device, somebody has to deposit with the court a bond that's equal to 100% of the bail amount. That bond says, okay, court, I promise that if the defendant doesn't show up, then you can keep this money. Typically, a bond dealer puts up this money because most defendants don't have that kind of cash on hand. And so the bond dealer will cut a deal with the defendant and say, if you've got a $8,000 bond amount or bail amount, then I'll put up the $8,000 if you pay me $800, 10% of the face amount. And then if you end up not showing up, I'll have to pay the $8,000 to the court. And so it'll be in my interest to track you down and make sure that you do show up. This surety bond is the most common method of financial release, and as you see from the trend from 1990 to 2004, its use has gone up. Similarly, conditional release that we talked about a minute ago has also gone up somewhat, while the own recognizance, the ROR, has gone down over this period. There are some additional financial mechanisms for release. So in addition to the surety bond, there's something called a deposit bond where the government says, you were going to pay that $800 directly to the bond dealer. Just pay us the $800. And if you don't show up, we will keep the $800 and we'll track you down and try to collect the remaining $7,200. But if you do show up, we'll give you your $800 back, and that way you're not out $800 as you would be if you made this payment to the bond dealer. So deposit bonds would be an alternative. There's something called full cash bond where the government says we're not going to take somebody's promise to pay. We're just going to take the full amount of cash. So give us liquid assets worth $8,000 right now, none of this promise to pay later stuff. And then there's property bonds where the government accepts some pledge of property rather than cash or a surety bond. Those last two, the full cash bond and the property bond, are not used very often. The surety bond most often, and the deposit bond somewhat. So some defendants have been released. The hearing date arrives. How many of those released defendants actually show up? Well, among released defendants in our period 1990 to 2004, which I think is still fairly typical of practice today, somewhere just shy of a quarter of defendants initially fail to appear. But most of those are temporary failures to appear, or FTAs. This is, well, to put it bluntly, these are just people who forgot. Very often people who are not living especially orderly lives or not always showing up to various appointments in life, and one of the appointments that they're not showing up to is the court date. And so lots of local courts find that if you institute a system of sending out reminders, placing phone calls or other messages to defendants or to some other designated person, then their failure to appear rate goes way down. In the end, you see, I'm going to turn to my right and flag for you the number of failures to appear under different measures. Apart from emergency release down here, where there's a huge number of failure to appears. Otherwise, in the roughly the mid-20s range, on average, if you put them all together, it's something just below, somewhere between 21 and 24% in any given year. The people who remain fugitive at the end of a year is a smaller group, somewhere between 3% and 10% for different methods, an average of 6% fugitive rate at the end of 1 year for the group as a whole. One other important question here: how many of these defendants who have been released are misbehaving in some way while they're out, during the period before their trial when they've been released? We don't know the full answer to that, but we do know how many have been rearrested. So somewhere between 14 and 17% are arrested within the year after they were released. But that's arrested for anything, felonies, misdemeanors, anything. For the felonies, it's more like 7%, and of those, a much smaller number of violent felonies. So those figures tend to be pretty stable over time. So we've talked about outcomes so far. Outcomes way back when, middle of the 20th century, outcomes now. How many people tend to be released these days? Now let's talk about the when and the who questions. First of all, when? When is bail set? Well, remember that when somebody is detained, they're detained based on probable cause to believe that they committed a crime, and that finding of probable cause by somebody, it might be the judge issuing an arrest warrant, or it might be the police officer in the field for a warrantless arrest, that probable cause gets tested at several points along the way during the criminal process. At something called first appearance in some jurisdictions, maybe later at something called a preliminary hearing. These hearings go by different names in different states. At each of these occasions to test the probable cause, bail might also be discussed on the side. There is also a bail hearing where the subject for consideration is bail. So if you think of it chronologically, initially the police officer is making a sort of release decision, and that is, do I arrest you or do I cite you? But then once you're taken to the station house, there is something called station house bail, where in many jurisdictions there's just a routine sort of price list connected not so much to your local ties, but just to the crime that you've been charged with committing. And then after that, you get a chance to revisit the bail question. And typically you're talking about adjusting the bail downward from there for those defendants who have stronger local ties. So that would be available at initial appearance, at preliminary hearing, or at the designated bail hearing. The written criteria that are being used for these release decisions are very much the types of factors that the Vera Institute recommended. So the emphasis here is on community ties in the rules, like we see in the Alabama Rules of Criminal Procedure. So the judge is supposed to consider relationships of the defendant, the, quote, identity of responsible members of the community who will vouch for the defendant's reliability, the defendant's residence, employment status and history, all the kinds of things that the Vera study pointed us toward looking at. What's written, though, and what's actually the criteria for decision are not necessarily the same things. Again, this is where the researchers come in. So various researchers have studied actual bail practices and other release practices. And they've noted that if you hold constant the local ties of defendants, if you find groups of defendants who have similar looking or identical looking local ties, you still sometimes get differential rates of release. So what would explain that difference if it's not the local ties? And some researchers like Toborg from 1981 concluded that the charge itself, the charge that that you are facing, the seriousness level of that charge, still drives a lot of the release decisions. And Ebbison and Konechny from in a famous 1970s study say that the prosecutor's recommendation, apart from local ties, apart from the seriousness of the offense, what the prosecutor recommends is still highly influential on the judge's release decision. One final interesting study to flag here relates to race and gender. The Ayers and Waldfogel study that's mentioned in your reading used an interesting market-based research design. They noted that Connecticut bond dealers charged lower rates to Black and Hispanic defendants than they did to white defendants. And Ayers and Waldfogel asked, well, what does that mean? And their thinking was that the judges, who really don't have a financial stake in the question, are just reacting to their perceptions of danger of the defendants, and that race and ethnicity was affecting that at a subconscious level. But then the people who actually have money on the line, the people who are asking the cold-blooded question, how many of these people can I get back into court so that I don't lose money? That is the bond dealers. They were charging a lower rate to Black and Hispanic defendants, suggesting that the real risk of those defendants failing to appear was lower than the court was estimating at the time of the release decision. Interesting study. Now, we've already seen that police officers and judicial officers set bail, police officers in the field or at the station house, and then judicial officers in the courtroom. And the judicial officers in particular get some heavy input from the prosecutors. But we have only mentioned in passing an important player here in implementing bail, and that is the bond dealers. I encourage you, first of all, do a Google search for bond dealers in your area. You'll end up with some really interesting sites and stories. Also, go down to the courthouse. Go to your local courthouse, take a camera, walk around and take pictures of the signs of the bond dealers. Really fascinating business, and ways of appealing to a captive customer base. The bond dealers, of course, put up the promise to pay the full amount of the bail if the defendant does not show. They do that in exchange for a fee, typically 10% of the face value of the bail. And then, of course, their job is to get those defendants there, because if they don't show up, then the bond dealer loses money. The insurance for bond dealers is normally based on an estimate that somewhere between 3 and 5% of their bonds are going to go into default and they'll have to pay it. The bond dealers do typically get a grace period. They don't have to pay on the day of a failure to appear. They get, say, 6 months to get out and get the defendant and get them back into town. And there are some great, fictional accounts of bond dealers out on the road with their, guns on hand. They get specialized rules for the use of force, and so movie makers have found them fascinating topics over the years. State regulators have also found them to be fascinating topics over the years, and so many states regulate the fees that they can charge given the coercive atmosphere where these transactions take place. A couple of states have outlawed this business, have just put it out of business, either just by explicit statute saying you can't engage in this business, or more frequently by setting up
deposit bond systems where you can just cut out the middleman and you don't need a bond dealer. So that's it for our survey of past and current practices of pretrial release and the when and the who questions of pretrial release. So our next conversation will relate to pretrial detention as opposed to pretrial release.